to sort of give you some background as to where my qualifications come to speak to you today. I was in Manchester as a district judge for 12 years, during which time I did do quite a lot of housing cases. Did one called Romano, you might remember. And then I went to Leeds as DCJ in 2010. I then acquired Bradford in 2012. I carried on doing that until earlier this year. Still done quite a bit of housing work, but obviously it changed when I became DCJ. I did more appeals and more contested trials. But okay, I'm going to give advocacy tips first of all. Firstly, trials. So my first point is, and this is that you might have a one-day trial or a three-day trial, whatever it is. We're all in it together, really. The judge and the say 2 advocates, 3 advocates, whatever it is. And the worst thing that can possibly happen is that you don't finish the trial within the allotted time, because then it has to come back. And it never comes back the next week. We all think, oh, well, we'll do it next Thursday. And there's always a reason why we can't. And certainly when I was DCJ, I was booked up for roughly 6 months in advance, although we could probably move a case if we needed to. But then one of the other barrister wasn't available. And so my experience is, on the few times this happened to me, it probably only happened twice, 3 times in 20 odd years, because I made sure it didn't. You'd come back 4 or 6 months later, and it's hopeless. Everybody's forgotten because they dealt with so many cases in the meantime. So that's a disaster we all need to avoid. And that's why I say, there's a rogue R in there, should say we all share the responsibility. In the sense, the advocates and the judge share the responsibility to get through the day, and bear in mind the judge has to have time to have a think about it, hopefully, and then give a judgment which is not just who wins and who loses, but why, because that's the important bit, particularly for the one who loses. I say avoid pointless skirmishes. We're all human beings. People can be very irritating. It's an adversarial process. You think, oh, I'll get a little dig in early, I'll put him or her off. It doesn't really work, I don't think. All it means is 10 minutes later, when you're having a dig about something he or she hasn't done right, they're having a dig back at you about what you haven't done right, or what your instructing solicitor hasn't done right, or your client hasn't done right. I say proportionate cross-examination. I recognise cross-examination is a skill. You set off preparing the questions you want to ask. The witness then says something, you're entitled to then follow that train of thought in the hope that something will come of it. So it's not that easy to anticipate how long you'll be. But in the contrary is, if you don't pay attention to how long you're asking questions for, then we get in difficulties in terms of the trial timetable, and the case can run over. So all I would say is, by all means, prepare your cross-examination, but if you've had a few answers that suggest, for example, that the witness is clearly honest, you might leave out some bits that you were going to refer to later and go down a different route, that the witness is misguided or forgot something or failed to notice something. And I say that cooperation is not a weakness. You should cooperate with the court, particularly the court staff, that's very important, the judge, less so, and your opponent. And that way, hopefully, you get to the end and you get a fair trial, which is really all we want. It'd be nice to get to the end and win, but that doesn't always happen. And anyone who tells you that they always win is not telling the truth. Right, this perhaps might be a bit more useful. This is an interim hearing, so I'm talking about you going to a court, appearing in front of usually a district judge on a procedural application. And this is what I think, things that work and things that don't. So, this seems obvious, know what you want to achieve. You think you do know what you want to achieve when you go into court. Well, express yourself as if you do. It happens sometimes that somebody comes in and spends 20 minutes talking at me, I say at me, complaining about all the terrible things the other side have done. And they've been late with this, and they've failed to do that, and they've not disclosed this, and this horrible letter where they were quite rude about me and all that sort of stuff. And so I think, well, that's all very well, but what is it you actually want? And I have actually said it afterwards. Just pause for a minute. What do you want? Or I might say more politely, what is it you want to achieve? What order you're asking me to make? Now, if someone asks you that, you've not done your job very well, because I would hope that in the first few sentences you would say, and it's not impolite to say, either I would like you to grant this application because, or I would like you to dismiss this application because. Very helpful, and the judge knows where you're coming from. Tell your submissions to the tribunal. Housing law is very technical, I accept that. The practice is difficult. A lot of it's counterintuitive. What you think should happen often doesn't, because the law or there's some regulations say a particular thing. You may have a deputy district judge who's a family practitioner who's doing his or her best but doesn't know that much about housing law. So with them you might want to give them a bit of background as to where the law is, and you might want to have it handy in case they want you to take them through it. Having said that, you might get someone who you happen to know is a housing law practitioner, and then you don't do the same thing because you're only wasting time. You might even irritate them by trying to tell them what an assured short-hold tenancy is. Structure your thoughts in a logical fashion. You go into court, you want to win. Don't get too excited. You want to do things in a certain order. For example, what you might want to say is, if you're opposing an application, if you grant the application, these things will happen. And one of the things that will happen or might happen is that the trial will have to be adjourned. What you don't want to go in is say the trial will have to be adjourned at the beginning, and then the judge doesn't really know why. But if you structure it in a logical way, you say, well, my opponent wants you to do this. If you follow what he or she says, these are the consequences. And obviously if you're opposing it, they're all bad consequences. But at least because you've structured it in a logical way, the judge thinks, oh, well, if I do this, then that will happen. And that might persuade him or her to dismiss the application. This is a phrase I picked up recently through being on various committees with government and the Civil Justice Council, where people speak in management speak, and you've got to remain agile. Well, I think what it really means is be flexible, and so particularly if you've not got a lot of experience of advocacy and you go into court for, say, the first time or the third or fourth time, you'll have written it all out probably, or typed it all out, you younger people, and you'll have it in front of you, and ideally you should be just left alone to sort of read it without looking like you're reading it, but just saying it because you've practiced it 3 or 4 times, obviously. The problem is some crusty old judge like me will go, yeah, I know all that, but what about this? And then it's like, and then it's a deep swallow, and you've got to then think on your feet a bit. And what I would say is, by remaining agile, is be flexible and anticipate that. I mean, some judges are just difficult for the sake of it. Other times it might be a genuine question, which is, I know you say you want me to do this, but surely if I do that, then this will happen, and that's a bad thing. And so you do need to say, well, no, it won't happen because, or yeah, it will happen, but it's not necessarily a bad thing because. So if you can anticipate the obvious, then have it ready. And if you can't, remain agile, and don't be thrown by it. Take a pause if you want, have a little think, and come up with something that doesn't show that you're quite as inexperienced as you actually are. Avoid petty point scoring with your opponent, similar to what I said about trials. It never really gets anywhere. And I think sometimes it is a bit of a problem where 2 solicitors have been falling out either on the phone or in correspondence, and then they go into court, they don't speak in the waiting room at all because they hate each other, and it comes out then in the hearing, and you can cut the atmosphere with a knife. Keep an eye on the clock, on the basis that the judge probably only has half an hour for this. He or she only has 5-10 minutes at the end to give judgment. You and your opponent need to sort of, if you can, fit it within the time. And make it easy for the judge. It's often said about skeleton arguments, you don't always need to do a skeleton argument in every contested application. But if you do, they say a good skeleton argument writes the judgment. So if you've put forward, this is what the case is about briefly, this is the law, these are my submissions, this is the end result. And if the judge likes everything you've said, you will see him or her sort of marking bits of it and hopefully reading chunks out as part of the judgment. And that's because you've made it easy for him or her, because you've set out what the law is and you've set out your reasoning. Easier said than done, but it's worth a try, particularly in a heavily contested application. Right, this is when it gets really educational. Okay, the cake and the dog turd. Now, obviously, that is a cake. I don't have much of a sweet tooth, but I do like the odd cake. My favourite's Bakewell tart. My late mother used to make a fantastic Bakewell, but I am partial to a chocolate cake now and again, which is what that is. Now, in this analogy, the cake is your killer argument. So you're opposing a possession case, and your killer argument is something like, we say they didn't serve a notice to quit or a notice of seeking possession, and they can't prove that they did. So if the judge accepts that, you're home free, you win, because there's no way they get a possession order unless they can prove that in most cases. So that's your killer argument. Now there's an argument where you put that in your submissions. I would say right at the beginning. Some judges are quite old, they forget easily, so give it to them first. Some people prefer it towards the end. I'm not a big fan of that. I think you go with your best argument first. And so I think know what your best argument is, put it first, make it nice and clear. The dog-turd, this is the other point, the one that your supervising partner says is your killer argument, but isn't. Now, I'm going to say he says that because it's bound to be him, and I'm sorry, it is. He's going to say this is a really good argument. The argument is, 2 years ago, they served a witness statement which was 10 minutes late. We didn't complain about it then or since, but now I think you should strike the claim out and award us costs on the highest scale known to man. That's your dog-turd argument. Now, what I say is, they do say about dog-turds, you can't polish a turd, but you can spray it silver. But this is a point that you cannot spray silver. It's a terrible point, and you really don't want to be making it. Because what happens if you put them together? Using this analogy, I like chocolate cake, and you get up close, you can smell the chocolate. But unfortunately, there's a dog turd sat next to it. And which you think is the strongest scent there? It's the dog turd. And to sort of put more context in it in terms of a judge's thinking, it's I had this good argument. I've sort of almost forgotten about it because I can't work out why he or she would say that thing, that terrible point about the thing 2 years ago. Am I being stupid? Is it more sophisticated than I think, or is it just a really terrible point? And why would they do that? I don't. So, and I've been distracted from the good points. So, and the tip I would give you, if you younger advocates, your senior partner, your managing partner would say to you, "This is a great point. Make sure you get that in." Unless he's there in the room, you don't have to. And even if he is, I wouldn't do it. Right, I'm going to touch on some bit of law and procedure. I'm dealing with two possible alternatives, and these are probably the most common defences that I saw in the last few months I was sitting. One of them, and I'm going to go through this very quickly, how to rent checklist, gas safe certificate, the deposit protection scheme, energy performance certificate, relevant contact details of the landlord or agent. These are all technical points, but if the landlord hasn't done that, and more importantly can't prove he's done that, then the landlord is not entitled to a possession order. And so I see, or I have seen, a lot of defences based upon breach of these requirements because particularly in an assured tenancy with a Section 21 notice, there perhaps isn't much by way of defence a tenant can put forward other than this. I'm not quite sure it happens. It might be that the defence solicitor says, well, if you haven't had any of these things, you might have a defence, and the slightly cynical tenant says, oh yeah, no, I didn't get any of those things. And so it's a bit of a try-on quite often. This happens, and it's an area that you as lawyers, depending on which side of the fence you sit, if you're advising landlords, it's then really important to instill on them how important it is, not at the stage of litigation, but at the stage of granting the tenancy, to not only make sure they give these things to the tenant, but more importantly, to prove that they've given these things to the tenant. Either by, for example, a good way is an email to the tenant's current address with attachments, and then the person who sent the email can give oral evidence to the fact that, yes, I sent that email, no, it didn't come back to me, and so therefore it's been served. A receipt from the tenant signed at the time saying I received these documents. Shouldn't be that hard to get. But I have done cases recently where the landlord had changed agents, fallen out with the agent wouldn't give evidence. And so even though I didn't really believe the tenant, the landlord couldn't prove that the tenant had had those documents. And so I dismissed the application for possession. I had another one where the landlord couldn't actually prove that he provided contact details for the agent who'd done all the documentation. And I sort of realised that this is a complete try-on. but that it probably was a good argument in law, but because it was a complete try-on, I said that the landlord has substantially complied, because actually the tenant had signed for other documents actually at the premises of the agent. She was actually there, so she couldn't honestly say, I didn't know where the agent was, because she'd actually been inside the premises. Now that may not stand up in law. I think if we'd gone to a chancery judge on an appeal, I probably would have come second there, but I was comfortable with it because it was one of those things that was, one, a try-on, and two, there's no real justice there. I could understand if the landlord's taken the deposit and kept it, then I've got a lot more sympathy with the tenant then. Second category is, I'm going to deal with, is counterclaims for disrepair. And there's really only three issues here. Firstly, is there an actionable breach? Secondly, was the breach notified to the landlord? Thirdly, did the landlord remedy the breach within a reasonable period of time? And in relation to each alleged breach or each item of disrepair, those three questions have to be answered. The difficulty arises for me in the procedure to establish that, because in a lot of these cases there might be 5 items of disrepair, there might be 55 items of disrepair alleged, but in each item of disrepair, those three questions have to be established by evidence, and then the court has to make a finding of fact on each one. So the instinct normally of a district judge is to allocate to fast track. Most cases are worth less than £10,000 anyway, and so most of us would say it's more fast track than either intermediate or multi-track. But you need to know how many witnesses there are going to be. Usually there might be 2 or 4. How many expert witnesses? Usually 2. One would be a surveyor paid for by the claimant solicitors. The landlord might employ a surveyor, more often employ an employee from the local authority if it's a local authority case. Will the experts give oral evidence? Usually not, and this is a bugbear of a former colleague of mine, Judge Walsh, who hated these cases because he said it was just impossible, because all you get is 2 reports saying 2 completely different things. You're then supposed to make some finding of fact, and it might just be, does the tap work or not? And one surveyor says it does and one says it doesn't. I still think it's a tricky one. It's a simple point, but how are you supposed to determine it when all you've got is 2 reports? I don't know. Very quickly, Griffis and TUI. I only say this because you might enjoy a journey out of housing law for a moment. This is a case which is a Supreme Court case from November 2023 and involves a claim for a holiday sickness. Mr. Griffis and his family did genuinely have serious problems in their holiday, made a claim. The claimant solicitors relied on a gastroenterologist and a microbiologist. The defendants didn't get a gastroenterologist, got a microbiologist, but then didn't serve his report. Not quite sure why. So it went to trial in front of a judge in London, and defence counsel said, well, although the microbiologist says that the food in the hotel is most likely to have caused the sickness and diarrhoea, actually the report's flawed, because if you look at it, he's not done this, he's not excluded cryptosporidium in the swimming pool, he's not excluded this, not that, and it's a very inadequate report. Anyway, the judge agreed with that and dismissed the claim because the judge found that causation wasn't proved. Went to High Court Judge Martin Spencer says, no, you can't lose when there's an expert's report which is unchallenged and you can't just go behind it. So it was quite robust judgment. Then went to the Court of Appeal. 2 out of the 3 Court of Appeal said, no, Mr. Justice Martin Spencer is wrong and the original trial judge was right. Very strongly dissenting judgment from Lord Justice Bean. And then went to the Supreme Court, and they unanimously found in favour of the claimant and said, if you're going to challenge what an expert says, then you have to bring him to court and ask him questions. And that's the only fair way to do it. And it's based on I think a 19th century case called Brown and Dunn, which most advocates are taught very early on in their career about factual witnesses, on the basis that you can't say a witness is lying about something or untruthful about something unless you've actually put that point to the witness and said, you're not being truthful about that. You can't just make it in your submissions without challenging the witness. It's based on the same principle. Now, the reason I mention it here, partly just to get away from housing law for a second, is if you think about the context of repair claims, you've got two experts there, neither of whom have probably been asked any questions by either side, and the reports have gone in, and they're not here in front of the judge. Now, according to Griffis and TUI, the judge has to accept each report because they've not been challenged by cross-examination. Problem is, the two reports say two completely different things. So my gut reaction is we'll just carry on doing things as we did before and ignore Griffis and TUI. But actually, according to that authority, it is a Supreme Court authority, that if you want to challenge the contents of the report, you should call the witness to give evidence. Now, if you do that in a repairs case, you're then looking at a multi-track trial or an intermediate track trial, because you're going to go over a day once you've started examining the witnesses. Right, moving on, importance of experts meetings and Scott schedule. They're really important in these cases. My experience is they're terrible in repair claims. And it doesn't help the court because they've not really engaged with each other. And so what they've really done is reproduced the original report in the Scott schedule. So it's worse than useless. And I know there was one case where I actually refused to try it because I said it was so the reports were so useless and the Scott schedule was so useless. There wasn't any way I could fairly try the case. And counsel both agreed with me. Antisocial behaviour injunctions, I've just thrown this in because I thought you'd probably all do them from time to time. The threshold is fairly low. I'm not going to go into the Act. It's section 1, I think, of the Act, of the Antisocial Behaviour Act. And all you've got to prove is that the defendant has been guilty of antisocial behaviour, and secondly, it's just inconvenient for an injunction to be granted to prevent any further antisocial behaviour. So we don't need war and peace. I get cases where there's 34 examples of the tenant telling his neighbour to. Now, I accept that that's antisocial behaviour to do that, but I don't need 34 examples of it, particularly with some more imaginative abuse as well. This is really important. If you're for a landlord and you're making the application, always personally serve the application on the tenant and always keep evidence of service. You're supposed to file it, but at least have it available. Bear in mind the first few hearings are often ineffective, usually because the tenant turns up without a lawyer and the judge will encourage them to get one. Then they'll have to get public funding. It's all going to take a while. So don't bring all your witnesses to the first hearing because you're never going to have a trial the first time up. Do a deal if you can. It will save money in the long term, and that's because enforcement by committal applications is expensive and a blunt object. The blunt object is for this reason. When I was sitting as a judge, I had three options. Commit them to prison immediately, suspend the order, well, fine in theory, but who's going to fine one of the sort of defendants that we get in those cases, or no order, which I used to call a bollocking. And that's basically the only options I had. Mediation and other forms of ADR. So what are the advantages of mediation compared with court proceedings? Usually quicker, that's obvious. Court proceedings quite slow. Secondly, significantly cheaper. Again, obvious. What you've got is a mediator, obviously you pay for, and then the two advocates, and maybe the solicitors will be there as well. But you're not having people giving evidence. It's not going to take 5 days. It usually will be done in half a day or a day. Now, some mediators can offer evaluative as well, just facilitative mediation. Facilitative mediation is where the mediator gets everyone together, discusses what their issues are, what they really want from the litigation, and helps them reach a negotiated solution. Those are the majority. But some mediators are able to offer evaluative mediation, which is where someone who's got experience in the field will say, well, I think that's a really strong argument because, or that's not a very strong argument because, or you may want to consider this, or I think a judge might think that that was helpful or not. Now imagine how helpful it would be if the mediator was a former judge who could say, well, I think a judge will go for that or not. Okay, the psychological advantages of a consensual mediation is really this. Someone goes to court, usually there's a winner and loser, one's really happy, one's really unhappy, and quite often angry, and they don't really accept they were ever wrong, and they say, oh, the judge was bent or whatever. The argument is for why they lost. But if they've reached an agreement, and it doesn't really matter what the dispute is, but if they both agreed to it, they've got a bit of a buy-in there that they've agreed to do it. And so I think you've got more chance of compliance long term if someone says they'll do something, if they did it voluntarily, rather than a judge imposing it on them. And the other thing that deals can be done, which include provisions which a court couldn't order. So for example, in a housing context, you've got a problematical tenant and intractable problems with the neighbour. My experience is those only ever get solved by one or the other moving. Now, as a landlord in a mediation, you can say, well, we've got this beautiful flat 2.5 miles from where you now are. It's right around the corner from your granny. We'll let you have that if you'll just leave and stop making these stupid counterclaims about this, that and the other, and we'll all walk away happy. And you can do that in a mediation, but you can't enforce that in litigation because you can only deal with the issue which is before the court. ADR is suddenly fashionable. Churchill and Merthyr Tydfil Council was a Court of Appeal decision in November of last year where the previous decision of Halsey was effectively overturned, and it said the court can impose ADR on parties to litigation provided it doesn't prevent them, if the ADR doesn't work, coming back to court and having the day in court if they want it. And it also has to be a proportionate means of achieving a legitimate aim. And you'll see that's obviously from our European legislation. NA and LA, that's exactly the same thing happened in a family case where they have actually changed the family proceedings rules from the 29th of April this year to mean that judges can force people to go for some sort of negotiated mediation. Both the Lady Chief Justice and Master of the Rolls have said that mediation, ADR, is the way forward in many cases. And Civil Justice Council are currently consulting about changing the civil procedure rules so there'll be a compulsory mediation provision which will recommend rule changes. My own experience is we developed a system certainly in Bradford County Court in York where small claims were made subject to judge-led mediation. Effectively it's a half-hour phone call, speak to both the people, usually litigants in person, try to persuade them to see the other side's argument and do a deal. And because it was an experiment, we did it for something like a year, and I kept all the statistics. And in both Bradford and York, 71 to 73% of the small claims were resolved at this half-hour hearing, which I've got to admit that did include those who didn't turn up. But it still resolved it, and it meant we didn't have to have a trial. And those who do high-value personal injury claims say that roundtable meetings and mediations result in settlement in 75 to 80% of cases. So it does work.